Welcome everyone, this is Tim Pullman and you're listening to the SEP Couch. This podcast is all about standard essential patents. We talk about patent strategies, friend licensing, patent pooling, and patent litigation. So let's dive into today's episode. She was the former Chief Counsel for IP and the Internet in the Judiciary Subcommittee on Courts of the U.S. House of Representatives and was earlier this year appointed to become the inaugural Chief Policy Officer for C4IP, which stands for Council for Innovation Promotion. I'm very happy to have here today with me on my SEP couch, Jamie Simpson. Jamie, welcome.
Thank you. I'm really delighted to be here.
As always, I'm interested in the person that I'm interviewing here, and I would love you, Jamie, to go and help us to learn more about yourself, go through your career steps, and give us an understanding of how you got in touch with the world of standard essential patents.
Yes, well, it was kind of a roundabout path. So when I went to college, I really thought I would become a research scientist. I studied biochemistry, worked in laboratories, and I just really found myself pulled to the social sciences. So I ended up going to law school. And I didn't want to automatically do intellectual property law, which is kind of the default for people who study science. So I experimented with just about everything else. But in my first job after law school, because of my science background, I got assigned an intellectual property case, and I just fell in love with it. Just such a fascinating area, especially when you understand some of the science. And my first case was in biochemistry, so I did, although I didn't really know the law very well at that time. I liked it, and that led me ultimately to apply to clerk at the Federal Circuit, which, as I think most people know, hears all the patent cases in the United States. And that really kind of got me on a path to really becoming kind of more of a specialist in intellectual property law. And the Federal Circuit sits in Washington, D.C. I moved from Chicago to join. And then I decided to stay in D.C. Because it's kind of in some ways a playground for lawyers. There are just so many job opportunities that it's not really the same in the rest of the country. And sure enough, a few years after my clerkship, I ended up joining the Patent and Trademark Office in the solicitor's office, which is the part of the agency that defends the agency in front of the Federal Circuit for some of the decisions. Now the PTAB, some of the things that they do, it wasn't when I started. The AIA had actually just gotten passed when I started, so I was there to kind of help the agency with some of the implementation, which is part of what attracted me to go there. And I was lucky enough to then start to have some opportunities to take details within the federal government, which, if anyone is thinking about joining the federal government, is a tremendous opportunity to get kind of a risk-free way to try different jobs. You still have your original station, but you get to try something else. So I got to work directly for the PTO Director for a couple of years. And then I applied for another detail to work on Capitol Hill, to work in the Senate. And I was fortunate to get that job. I worked for Senator Chris Coons from Delaware, and he is very interested in intellectual property, and he himself has a background more in trademarks, but he's very interested in patents. Interested enough that he was willing to take on a detailee to focus on IP full-time. And I got to do that for a couple of years, and I just found being on Capitol Hill fascinating. So when a position opened up at the House of Representatives, kind of in the same area, the Chief Counsel and the IP and Courts Subcommittee, I was thrilled to be able to do that and to work on the other side of Capitol Hill and work there while the Democrats were in the majority. I was on the Democratic side, so I got to run hearings and things like that, to work on bills. And then when Dave Kapos and Andrea Iancu started C4IP and asked me to consider coming over, I think maybe 6 months after they had started, it just seemed like a tremendous opportunity, and what they're doing seemed like really important work and would allow me to continue what I was so interested in on Capitol Hill. And So that kind of brings me to today. I hope that wasn't too long of an answer, but now you know where I come from.
Perfect, Jamie. Thank you so much. Very interesting. And I want to follow up also really on this because you have a policy background and working with and close to the US government. We have many listeners in this podcast outside of the US, Europe, but also in Japan, Korea, China. And it would be great if you could elaborate a little bit more. How is IP dealt with in the US? And in particular, of course, also the topic of standard essential patents. What is your impression? Any particularities that you have in mind there?
Yeah, so you learn a lot by working in the government. It's certainly more complicated than I appreciated from the outside. The one thing I think that maybe is not apparent is just when the executive branch takes a position, just how many different entities in the federal government get involved. So for something like standard essential patents, especially, the PTO is involved from the patent perspective, but all the antitrust agencies are also involved. And that's Department of Justice. They have an antitrust division. The Federal Trade Commission engages antitrust. And then there are parts of the White House that engage. There's the Office of Science and Technology Policy. There's also the Internet or the Intellectual Property Enforcement Coordinator, the IPEC, which is another IP position that's in the White House. And the PTO sits below the Department of Commerce in the US government. So the Department of Commerce also gets involved. So whenever you're developing a policy position, all of these people get invited to the table, and you're not really able to go out publicly with something until everyone's agreed. And, especially when you're talking about patents and antitrust, you often have groups that are taking completely different approaches to the same subject matter and might have very different opinions, and that can make it very hard to come to consensus. And then you're just talking about one part of the federal government. So that will, allow the executive branch to come out with a position like they did in the past with the policy positions on standard essential patents. But that's different than what Congress might decide, and it's different than what the courts might decide. So, in a lot of ways, there's not necessarily a unified government position at any given time. But that's, I think that's it in kind of a nutshell.
Right. I mean, which is important. Of course, we also need to have independent courts and judges that, can independently from frameworks, from regulation decide. And I think, especially here in Europe, we are happy to have such a system here, and every democratic country, I'm sure. If you would think about the past years, 10, 15, maybe 20 years even, think back, what has changed in the IP policy in the United States? I think many people, especially patent owners, kind of complain that it's harder and harder to enforce their patents in the US, and injunctions are almost impossible. I keep hearing that, but what is your opinion, or what is your observation of those past years and where the US government stands with IP and how they value it?
Yeah, that's a really good question. And I've definitely seen an evolution over the course of my career. I think one really important factor is that between the creation of the Federal Circuit in 1980 till about the early 2000s, the Supreme Court didn't take a lot of patent cases. So the Federal Circuit, which had just started, was really kind of in control of patent law in this country. And then in the early 2000s, the Supreme Court just really started taking a lot more patent cases. And when I say a lot more, it's not a ton more, it's maybe 3 to 5 a year at most, but still, they pick the important cases and they have a really profound impact. And in particular, they just started reversing the Federal Circuit a lot. And I think you mentioned one of the cases on injunctions, which is the eBay case. And basically reverse the longstanding presumption that you get an injunction if you win your case in the United States. And you can still get an injunction, but it's a lot harder, especially if you're not a direct competitor of the company you're suing. And that ends up really changing the dynamics. more so, I think, in negotiations and in settlements, it just gives a lot less leverage to the patent owner. And I think that's had a really big impact. And that's just one case. There have been a lot of areas of law where the Supreme Court has, essentially reversed the Federal Circuit. And most of the time, that's ended up weakening patent law. And then the other big change is the creation with the 2011 America Invents Act of the Patent Trial and Appeal Board, or the PTAB, which is an administrative proceeding to judge the validity of patents on kind of narrow grounds, just obviousness and novelty based on printed publications. But that also, if you look at the numbers, has become the biggest single patent forum in the country. It's, hearing just a tremendous number of cases, and it's had a very big impact. Again, it just changed the dynamics of the normal court cases, and it changed settlement discussions. And the way it's set up, and there have been changes over the last 10 years as it's kind of been in existence, but the lack of ability to kind of have quiet title in your patent, even if you survive one challenge at the PTAB, there is the possibility that more entities can challenge your patent. And that's really hard from a business perspective to work that risk calculation into your business model. So I think we're kind of in the middle of a lot of changes here. And I personally do have a lot of sympathy for patent owners who feel that the pendulum has swung against them at this point. But if you look back at US history, that has happened, that the pendulum swings back and forth. So I'm hoping that we'll kind of get to the middle, and maybe at some point we'll figure out how to keep it in the middle instead of going back and forth. That would be the goal, but that's really hard to achieve.
Right. Understood. Yeah. Let's hope it's somehow balanced so everyone is happy equally or unhappy equally. I keep saying that. That's also a good balance. But what is your opinion on regulation in general? My observation often is that everyone discusses these litigation cases, and these are important. Of course, it's millions, sometimes billions of dollars of royalties, and then I think even Obama in his administration commented on patent trolls, and it gets a lot of attention. But now, and that is okay. But now basing regulation on these tip of the iceberg cases, where most of the deals, at least in the industry that I'm very known about of SEPs, are handled, and where we see a lot of deal making as well. What is your opinion on that? What is the perception on, is the IP world working or not?
Yeah, and I think you kind of hit on an important point there, which is that I think some of the things that make a lot of headlines tend to get the reaction from policymakers. And that was certainly true of, so-called patent trolls that really animated a lot of the American Invents Act of 2011. And it's easy to focus on the bad actors and not kind of ignore or take for granted the rest of the system that's working pretty well. And I do see that in standard essential patents as well, that I think there have been high profile litigations for sure. And, especially in the wireless space, it's really important for the economy. There's a lot of money in it. We all use our phones, so it's important to, everyday people too, you care about making sure that that works and that your phones can talk to each other. But there are just a number of standards out there that are doing completely fine. I was surprised as I learned more and more about this, just how many there are. I knew Wi-Fi, I knew 5G, and other wireless ones, but there are ones that just operate completely under the radar. And even for the ones that are prominent, I think part of the mistake is thinking that just because there's litigation that the system doesn't work. I mean, the courts are there for a reason, and they're there because sometimes you're going to have business disputes, and that doesn't mean the system's not working. And in fact, I think oftentimes that means the system is working. And I think you see that especially when you have some high profile cases that set down certain rules of the road, and then kind of litigation slows down. And I think you kind of saw that after the first wave of wireless litigation, that the volume has actually decreased if you look at some studies. So I'm not against regulation when it's needed, but I really think you need to look at the data and make sure that it is needed, because I think if it's not, I think there are a lot of reasons just to let businesses play out on a relatively free market.
Right. And I mean, I think also it's quite natural then if there is a disruptive technology changing a certain new industry, right, like the automotive industry, of course, we can also expect disruption in how IP is licensed, right? And that may lead to disputes, which, it's a lot at stake. So I think that is a perfectly normal reaction to that disruption. But let us talk about more about a specific regulation, of course, that I think for 2023 has created most of the debate, right? And ever since it got leaked and then published and all, we all followed that closely. We've seen many SEP holders to be very upset about it. Implementers, I would say the majority promotes that regulation. Not everyone, but many do. And I keep saying, if not everyone is equally unhappy or happy, then it seems unbalanced. But I would love to hear your opinion on it. Are there any parts in that regulation that you feel could solve a problem, or is the whole regulation, in your view, over the top?
I guess, frankly, I am pretty pessimistic about the regulation overall. I don't think all the ideas are bad. I think a good example is more transparency, in that they propose a registry. And I think the idea of transparency is good, but I don't know that having government intervention right now is the best approach, especially given that organizations like Etsy already have databases. I think a more sensible approach might be looking at how to make that one better. And if that doesn't work, maybe there's a stronger case for government intervention. So, that's one area where I think, the underlying idea is good. And kind of just turning more to the regulation, the proposed EU regulation more generally, I do think the case hasn't been made for it. And that's, to me, the first fundamental problem. The independent study that the EC commissioned didn't really seem to find an overwhelming case to be made that the litigation was so out of control that there needed to be regulation. And I know there's kind of a lot of speculation in various reports that because of the Internet of Things, because of more companies, especially small and medium enterprises, potentially being implementers, that they might have a really hard time accessing the system. But as I've looked at this more, I think, again, the case hasn't really been made there. There hasn't historically been a lot of litigation against small and medium enterprises. If you look at some of the submissions from the bigger standard essential patents holders in the EU and in the US to the PTO, they've said it's usually not worth their while to go after the smaller ones. And I think even more importantly, and I didn't appreciate this at first, but even though there might be a lot of small implementers in the Internet of Things, the patent holders have the option of licensing anywhere in the supply chain. And there are different points at which there aren't as many companies. So they will preferentially go to that part of the supply chain, which is to say, this is to me an example of a very complicated market kind of showing its own solutions to problems. And I think unless it kind of proves unworkable, again, the case hasn't really been made for regulation. And then I think in the proposal itself, there are just, several things that, I kind of scratch my head at a little bit. One of them is the EU IPO, which, I'm not pretending to be an expert in European administration or government, but, I think it's clear that the EU IPO has not to date specialized in patents. So this would be something entirely new that they're standing up, which which is challenging for any organization. And then the timeline being proposed, there's kind of two problems with that. One is that, I agree with the many commentators who have talked about an access to justice problem, that you can't go to the courts. And, I agree with that. And then second of all, the 9-month timeline strikes me as highly unrealistic for just how complicated this is. In my last job, I covered patents, copyrights, trademarks, trade secrets. And one of the things I ended up getting involved in overseeing was the Copyright Royalty Board, which in the United States sets royalty rates for musical compositions. And it's undergone a number of reforms over the years, but in its current state, every 5 years, it's supposed to come up with a new royalty rate for this particular copyright. And in the last cycle, they didn't come up with the royalty rate within the 5-year window. So they entered the next 5-year window without having the first one done. And in a lot of ways, copyrights are simpler than patents. No one's contesting the validity of the copyrights. No one's asking whether or not they're, essential to a standard. So, 9 months, I think, is asking a lot. And I'm not, convinced it can happen in that time. Maybe it will, and if it does, maybe the data it puts out isn't that useful, which again will cause its own problems. So, I think I'm sure this was really well intentioned, but I do have concerns that it's just not going to hit the mark of what the intention was.
Well understood. If you think about it, taking 3 steps back, more on a geopolitical view, especially US, as an American working close to the US government, I keep wondering, I mean, we all know that SEP licensing is global, right? And
Right.
some local courts even have made global FRAND decisions. And I think that regulation is very similar, based on a only European patent register, right? It will only have European patents in there, based on, FRAND determination by that European agency. They want to set a global rate, right? And how, if you now think in view of the US, and I know there have been also letters sent to the European Commission from former US officials and the US government even, how is that problematic in a geopolitical sense?
Yeah, I think that is a very important question. Patents have historically just been territorial. And, with standard essential patents, you kind of have the added complexity of these, companies who commit their patents, and that's more of a contract. And the contract is more global in nature. But when you have, territorial courts affirmatively setting the global rate, I think, it ends up, kind of depriving other countries of implementing their full patent policy. And it also just, sets up forum shopping incentives, to either be the favorite place of the implementers or the favorite place of the patent holders. And in a lot of ways, it kind of sets up a race to the bottom, however you want to position it. And I have to agree with some of the statements that have come from US officials recently. And I'm thinking of USPTO Director Kathy Vidal and the Commerce Secretary Gina Raimondo, who've kind of pointed out that this is a global problem that needs a global solution. And I think it really is an area where it kind of calls out for if different courts around the world are going to decide this, you should all at least be kind of adhering to the same standards and the same principles. It might just be a foregone conclusion that a national court has to make a decision, but should all be playing by the same rule book. So you kind of do away with some of these forum shopping incentives. And that's kind of a longer term process, but the real risk you have in not doing that is what I think kind of happened with the EU proposal, which I think came out or was leaked in April or whatever the date was. And in June, you saw China propose, a different national regulation. Right. And, I think that's kind of to be expected because, no country is just going to want to sit back and let another country take the lead on, such an important area of technology. But at the same time, if we all do that, we're all going to kind of end up undermining each other. And that doesn't work to anyone's benefit either.
Yeah, that makes a lot of sense. And sorry for asking you so many questions about the EU regulation. I want to learn more about now the US. We heard already China, in maybe even in reaction to that regulation proposal, came up with their own. But what is the US doing? As we all know, they have just withdrawn the former policy from 2019 last year in June. And you know, right now, what is the situation? Can you give us an update here? What the US idea is about, you know, how to think about the standard essential patent licensing world, if they want to, you know, come up with some guidance, something, or do you think they will keep it as it is with not a policy in place right now?
Yeah, so first of all, you know, the withdrawal of the guidance that happened earlier in this administration, you know, I think that was sensible. I think the guidance that has come out beforehand was, you know, very much overinterpreted based on the context in which it came out and not what it literally said, because they were all pretty moderate in their actual language, but that's not how they were interpreted. So I think, you know, the idea that there are in the US a lot more court cases that set out the rules of the road, and, you know, kind of let licensors and licensees know what they have to do, and, you know, let the licensees know if they hold out too long, they might face an injunction, but let the patent holders know if they're not offering a FRAND license, then, you know, they're not going to get an injunction. So it's really creating the right incentives for both sides, I think. So I think that was good in and of itself. You know, I think what remains to be seen is how the US is reacting to these proposals in the rest of the world. You know, to date, there hasn't been any legislation introduced, or, you know, any other proposals from the administration. I think if the US were just operating on its own, we probably would at this point just, you know, leave it up to the courts unless, you know, something else unexpected happened. But I do think with, you know, proposals potentially going in effect elsewhere, that'll put pressure on the US not to sit by and let, you know, essentially let policy decisions be made by other people. That being said, I don't know what shape that will take here, as you know, especially since there haven't been any bills introduced, but haven't even really been that many proposals, or really any that I'm aware of that are very public. So I think, you know, I think people right now are reacting to these other proposals and trying to think what makes sense for the US.
Interesting. I heard rumors, and I don't know how far that went. Some bigger tech companies from the West Coast have been proposing a US bill setting up like a federal SEP royalty court with global impact, which sounds a little bit like, you know, that agency they want to set up in Europe. Have you heard about this? And in your experience as an experienced, you know, policy expert, do these kind of proposals of bills, you think they will even become, you know, relevant or law, or is that, you know, to be ignored? Any experience there?
Yeah. So I definitely am aware of that proposal. That and it was very much, you know, a proposal that was not made public. So which is to say, I think even the people who were behind it were appreciated that it needed more work before it kind of saw the light of day. Which is wise. You know, before you actually go to the public, you want to put your best foot forward. And I guess I would say that I think in the US, you have your best shot at getting something done, where before you even go to Congress, you've kind of reached some compromises. You know, the best thing you can do is, you know, reach across the metaphorical aisle to your, you know, your competitors. So if you're an implementee or implementers, and, you know, see, is there anything we can do here? Because if you can go to Congress with a package you kind of agree on, you know, Congress is going to be thrilled with that. You know, that's not to say they're not going to need to see some more changes and, you know, to consider the public policy and the impact on consumers and all of that. But if you can kind of come to Congress with some consensus, it makes a huge deal of difference. And I saw that when I was on the Hill, again, in the copyright space, there was huge copyright bill that was passed in 2018 called the Music Modernization Act. And a centerpiece of that bill was rights holders on the copyright side working with licensees, mostly on the kind of digital internet side. So, Spotify and Pandora and companies like that. And they literally came together and said, we have a huge problem under this United States 100-year-old law that was created at the time that we were using piano rolls, and we're operating under that same law for the internet age, and wasn't working for anybody. So that meant there was really room to kind of come to an agreement, and they did. And it still took a while to get it through Congress, but just starting out on that footing meant that it actually got passed. And so, I could see something in the SEP space happening like that. And I think that would be good. And I think, again, this is kind of judging from the outside, but I feel this might have been something that didn't happen with the European proposal, in that I'm not sure all the stakeholders came together. If that did happen in the US, I think that would help a lot to get a law passed. In the absence of that, frankly, I think it would be very hard. Both sides of the debate here, it's more simple than two, or it's more complicated than two sides. But they're both very powerful sides that have a lot of allies in Congress. So it's very hard to get something through if it's one-sided.
Interesting, very interesting. Great insights, Jamie. Maybe to sum it all up, I would love to hear a little bit more. You've been working in the US government for years, and now you work for C4IP. Can you let us know a little bit about what that organization does? And of course, also because, we and our listeners are particularly interested in SEPs, if they're, how are the SEPs topics treated there? Anything we can look forward to next year? Any forward-looking projects in place?
Yeah, so C4IP, I think, is a unique organization in that we're very small. There are 2 employees, myself and the executive director, and we have a very active board of directors that's co-chaired by 2 former PTO directors. And so there are people who have engaged in the policy space for years and have also worked in private practice. And because it's small, we're able to take policy positions pretty quickly, as opposed to some organizations in the US. And I assume there are organizations internationally that work this way as well, have a list of members and they have to go to them and get a vote on things. And that's good in its own way, but it takes time. And one of the things we're able to do is react more quickly. And so we do that because the policy debates move quickly. And standard essential patents are very much on our radar because they are, so important to, the technology and, innovation. And they've added so much to the economy and to consumers around the world. And I think, especially with the regulations that are being proposed internationally, it's something that, even though the US hasn't necessarily decided what it's doing, I think it's very active. And you can see that from the fact that the Patent and Trademark Office in the US issued a request for comments earlier this year. Those comments are all in and available on through their website. So I think there's some indication that the administration might be looking to do more. But it's also clear by the number of comments that this is something that U.S. companies who are operating internationally, in most cases, obviously, are interested in. So it's something that we're interested in. And I think we've kind of made it publicly clear that we have concerns about the EU proposal, but in terms of being publicly in favor of something, I think in the US, we're very much in favor of having stronger injunctive relief, which definitely would impact the standard essential patent space. But I think beyond that, we're still considering what might make sense for the US.
Very good. Thank you so much, Jamie. And the very, very last question now, which is always your final pitch. What do you want our listeners to keep remembering from your podcast episode?
Well, I think I'll be repeating myself a little bit here, but I think, what impressed me when I started working on the standard essential patents issue is just how critical they've become to our global economy, and just how much value they bring to people every day. You know, you take it for granted that our phones can talk to each other. But we can't take it for granted that unlimited tinkering with the system won't necessarily lead to it unraveling. And I think most prominently, I think it's important to understand that there are really a handful of companies that contribute to most of the standards, whereas there are a lot of implementers. And if these companies that create the standards can't recover their investments, that means they can't invest in the next generation. That means that ultimately, you know, the system that, you know, has brought so much value might really start to fall apart, and we might, you know, get siloed, different pockets of technology that can't talk to each other, and that would be a real detriment. So I think that makes a really strong case for policymakers to be cautious and careful, and to make sure whatever they're doing is based on the best available data, and that they move slowly to see what impact their policies have. So yeah, that's my kind of nutshell that I hope people take away from this.
Great. Thank you so much, Jamie. That was Jamie Simpson, Chief Policy Officer with C4IP. Thank you all for listening in today. I hope you hear you at the next episode, and goodbye.